לי יאלי.
יאלי, איפה אתה גר עכשיו?
אני עדיין ליד ירושלים, באלון.
אתה נמצא לחיפה כל הזמן?
יצאתי 4:45.
וואי, קשוח.
We start, Al.
Okay. So, hello everyone and welcome. Today we have with us our friends Einat, Albin and Omer, who will discuss workers' privacy right in an area of cybersecurity. Dr. Einat Albin, which I'm sure most of you know, is an associate professor at the Hebrew University that specializes in labor law. She is also the academic director of the Minerva Center for Human Rights. And Gil is currently a researcher at the Israeli Institute for Economic Planning. And also she serves as a TA at Tel Aviv University. Prior to her current work and her master's degree in economics, Gil worked as an attorney at the top law firm in the field of capital markets. So we have an article in Hebrew and an abstract and a presentation in English. And we have also two controllers of the presentation. So we are in cutting edge technology and linguistics. So Einat and Gil, the floor is officially yours. Thank you very much.
Thanks so much, Al and Yuval, for the invitation. So lovely to see here many friendly faces, old and new. Danny, hi. Very, very fun to have you here.
Is Danny in the old or new category?
Danny is old, but
Too
very
old, too old.
old but very dear. So this article that it's a draft article, so we'd love to get your responses and thoughts on it. I come from labor perspective, just only 2 years into learning about cybersecurity and delving into the right to privacy in this context. And so really anything that you can give us your thoughts on, that would be brilliant. So as you all know, I guess, Israel now, there's a new cybersecurity bill. It's from 2018. Within the bill, there's a specific article discussing the right to privacy of employees and of customers. And we began thinking of this issue in the past 2 years. How should such article be set? What are the rules to be established? Whether there is need for such an article within the bill, given that the laws regarding privacy at work are generally set upon court decisions that apply a general court judgment, which we will discuss. It's called Isakov Inbar, given by the National Labor Court. And so we delved into this question, looking also at employers' challenges, of course, within an era of cybersecurity, the business operation, the legal obligation to protect databases, which employees also have an interest, of course, of securing these databases because much of their personal information is within these databases. And at the same time, the increased monitoring of workers' activities that are done in the cyberspace, seeing them as potential violators of cybersecurity and hackers, and therefore almost all of their activities are monitored in various ways and various devices. Therefore challenging their right to privacy, not of their data within the databases, but of their privacy in the workplace, because a lot of information is gathered on the workers in this monitoring process, leading us to question how is what kind of information is gathered, from what sources, how it's analyzed, and what are the results of the analysis that lead employers to look more carefully into these workers based on this information. Cybersecurity today is a top priority, a national effort in Israel. There was an establishment of the Israeli National Cyber Directorate, and as I mentioned earlier, the Cybersecurity Bill. Privacy at work is currently in a situation of sort of a legal vacuum. The Privacy Protection Act of 1981 and other legislation do not address the unique context of employment. It does not address issues regarding power imbalances within the employment relationship that might affect the way we look at the right to privacy, and especially in this regard, the meaning of consent. How do we look at consent as a requirement of privacy within the definition of what is privacy in the Privacy Protection Act when we're talking about workers, given this power imbalance that leads many times within labor law to see that consent is not necessarily should be given, right? And not necessarily accepted within this relationship, saying that the workers will agree to everything. So how do we address this power imbalance in the meaning of consent? There is no clear answer to these issues currently. And then, therefore, because of this legislative vacuum and no specific attention given to the context of employment, we have this court judgment given by the National Labor Court in Israel called Issakovim Bal. What we did in this research project is we looked at how Issakovim Bal will be implemented in regards to cybersecurity, given what we define as the basic law of cybersecurity that governs the cyberspace in Israel today within the world of work. So we point to two main characteristics of the basic law that applies today to the workplace in regards to cybersecurity within the first chapter, and on that basis assess how Issakovim Bal will be implemented in case of cybersecurity. So one of the main characteristics of the basic law that applies to the cyberspace in regards to labor, not only labor, I think it regards to cybersecurity generally, is a securitization paradigm. And we can see the securitization paradigm very strongly also in the Israel National Cyber Directorate website, in the proposed cybersecurity bill. Here are a few quotes. In the website, it's written that the National Cyber Directorate works to secure the protection of the state of Israel in the cyberspace, talking about ideas of protection, saying that the Directorate is a national security and technology body whose responsibility is the protection of the national cyberspace and the promotion of Israel's fortitude, otzma. I didn't know what the best English word for this, but it's really, a military language in the sense of securitization, very strong securitization. In the cybersecurity bill, it's written that the Directorate is a governmental body whose mission is national security in the field of cyber, really using these words of national security. Now, the strong securitization paradigm has been questioned. In the literature, Helen Nissenbaum pointed to two possible paradigms of cybersecurity, one that is related to technical protection of databases and the other of national security, showing how each one of these paradigms affect the way we approach cybersecurity and regulate cybersecurity. What are the norms through which we regulate cybersecurity? Therefore, offering us new ways to look at cybersecurity, not necessarily through the securitization paradigm. And also the OECD a few years ago moved from the notion even of cyber security that focuses on the paradigm of securitization, national security, very much associated with national security, to discourse focusing on digital protection. And this is something that we will show how it's the paradigm of securitization has a very possible impact upon the way the right to privacy will be addressed within the workplace. And we offer also to use it in very limited circumstances. I'll show this in a minute. The second characteristic that we found about this basic law of cybersecurity within the workplace results from the way the three general players or actors within the field of cyber security are governed by the law. So we showed how the National Cyber Directorate, what laws govern the National Cyber Directorate, cyber companies that develop the cyber technologies and sell them, redesign them within the workplace, and the employers, which are the organizations that use such technologies. And what we show in the paper is that the securitization paradigm and the web of laws that apply to the three main actors in the field of cybersecurity lead to increased employer prerogative, easily enabling excessive monitoring over worker performances and a collection of their personal data. We show that activities that would have done by any other actor, not necessarily employers doing the same things, collecting these data, would not necessarily been legitimized by the law. And this increases the employer prerogative using the justification that what it does is to protect the cyberspace, enabling a wide range of activities to be done, a wide range of sources from which to gather data, almost no limitations on the data itself that is collected. And we have various examples, again, discussed in the paper, for example, of information gathered from WhatsApp groups that the employer is not included in, from personal phones, from personal computers, from voice devices, etc., in order to enable cybersecurity, and almost all data is gathered and monitored. Just to give an example from the last few days, I'm sure you read in the news that the Iranian hackers leaked data from the Israeli LGBTQ dating app, Atraf, and from other various companies, including Pegasus. The discussion on these hackers' activities was related to Iran, to issues of national security. But we want to argue that in many of these situations, we have to address the issues of protecting data within the workplace as not necessarily a security issue of securitization in the form of national security, but mainly as an economic and market-oriented activity, and therefore a market and economic and market paradigm should be adopted. We provide an explanation of this within the paper, arguing that securitization, the paradigm securitization, is only fit for minimal situations, for example, issues that are issues of national security, of significant social and environmental purposes, where there's strictly confidential materials involved and high level of security is needed because the damage is too high and it's difficult to balance it with other interests. In comparison, we think that all other matters related to data within the workplace should be thought of not necessarily through a securitization paradigm, but rather through an economic and market-oriented paradigm, ensuring the proper economic functioning of the business, data that is not necessarily highly confidential, and when security can be balanced with other interests, for example, the interest of privacy of employees. So against this background laws, where I said there are two main characteristics, one securitization, the other is a basic law that enables, through the prism of securitization and the laws applying currently within the workplace, for very high employer prerogative, legitimacy to employer prerogative to take any actions almost in order to secure the private place. We'll turn now to see how Isako Vimbal might be in these circumstances, and
So I'm going to hack your computer. Okay, so first, hello everyone. It's very nice to be here. So as Einat said, since the Israeli labor courts have not yet addressed in a direct manner issues regarding cybersecurity with respect to privacy, in the paper, we leaned on our findings from another study we conducted, in which we reviewed all the labor court judgment that mentioned Isakov, since it was delivered in 2011. And so I'll first give a quick summary of Isakov and of our findings, and then we will talk about the implementation of this conclusion in the context of cybersecurity. So in Isakov, the National Labor Court combined two appeals concerning the admissibility of email correspondence. One's appeal of Isakov. Isakov sued her employer, claiming that she was unlawfully dismissed due to her pregnancy. The employer, to support its claim that she was fired prior to the pregnancy, wanted to use emails from her work mailbox. The regional court, labor court, ruled that the emails were admissible, and since Isakov was aware of potential mailbox monitoring, the court concluded that she gave her implied consent to this monitoring. In Afikei Mayim, the regional court ruled the opposite way. The employer wanted to use emails to support its claim that a senior manager at Afikei Mayim caused the company significant financial harm. But the regional court ruled that the evidence was obtained through unlawful means, through privacy violation, and that the emails were not admissible. Okay, so the National Labor Court ruled in both cases that the emails were not admissible, and the court set the main rules regarding privacy at work and the use of emails and other digital technologies at work. The court judgment is based on a balance between workers' right to privacy and the employer's prerogative to property rights over their computers and other technologies that they provide to workers. According to this judgment, in order to monitor the digital activity of their employees, so workers must follow certain rules. One, the employer should have a clear policy on the use of cybersecurity within the workplace. It should distinguish between its use for work interest and personal interest. Second, the court makes a distinction between three types of mailbox: business mailbox, mixed purpose mailbox, and private mailbox. And while the court ruled that with respect to business and mixed mailbox, the employer can monitor workers' activity subject to other conditions set in Isakov. The employer is not allowed to monitor privately owned mailbox. Third, the employer's monitoring policy should apply the following principles. legitimacy and finality, specific purpose, transparency, proportionality, and consent request. According to the proportionality principle, the monitoring should be proportional to the potential harm to the employer. And this is very important with respect to cybersecurity, to the extent there are no other alternatives, other technologies which are less invasive. And according to the consent requirement, the employer must obtain in advance the worker's willing and informed consent with respect to the general monitoring policy and to any specific monitoring of personal content. So the purpose of this slide is that you can get a feeling of the materials that we reviewed. We can see here that out of the 51 cases that applied Sakharov, only 2 judgments were delivered by the national court, and most of the cases were in Tel Aviv court, labor court. We can see that most cases talked about the admissibility of evidence. A few cases involved compensation claims, and 2 but notable cases were about deploying a policy that violates the right to privacy. One was the deploying of a biometric clock in a Kalantzwa case. And the second was about a system that monitors the use of government cars. In both cases that deployed a new policy, we can see the involvement of labor unions. This was one of our observation. Our main findings are that most cases involved ex post protection of privacy. For example, admissibility of evidence after the violation occurred, the violation of privacy occurred. And we can see a small compensation payouts around 10,000 shekels that in our view does not impact employees' behavior. We show in the paper that the proportionality someone else hacked the okay. So we show in the paper that the proportionality principle was narrowly and partially tested. The examination of the technology we saw only in a few court judgments. Again, only when the labor unions were involved. We see no use of technology experts. Another finding is that despite the fact that the Israeli privacy law is based on the consent model, in cases where there is a legitimate purpose with significant importance to the employer, such as protecting trade secrets or preventing severe harm to the business, the courts do not examine the consent requirement. Overall, we can see 3 main approaches to the consent requirement. Those approaches based on the circumstances in each case. We can see that on the one hand, there are cases where the consent is concluded by the court as irrelevant or not examined. Those cases are, as I stated, that when the court concluded that there is a legitimate purpose with significant important to the employer. On the other hand, we can see a situation where the court perceives the consent as cogent, as the employees cannot waive their right to privacy. Those situations are usually when the employer requests you monitor private mailbox or web browsing of the employer. In between these two extremes, we can see that courts examine the consent requirement, but they give it little weight compared to other considerations. Okay, so now we can talk about the implementation with respect to cybersecurity. So Einat, this is your.
Thanks, Gil. So as Gil said, there is currently no court judgment in Israel among the 51 that were provided in national courts, in the district courts that discuss particularly cybersecurity issues. And therefore, what we did was assess which one of, how would the laws as applicable by the courts so far in all 51 cases and described by Gil will be applied in relation to cybersecurity. So we of course assess that it is likely that cybersecurity will be viewed as a legitimate cause for monitoring and for data gathering. We also assume that given the securitization paradigm and the interests of those involved in developing the technology and of employers to take extreme measures to provide such protection, that consent will not necessarily be required by the courts, as in the situations that Gil described earlier of protecting trade secrets and preventing harm to the business. Because of the employer's obligation to protect databases and because of, again, the securitization paradigm that really governs the discourse, this is one of our concerns. And actually, discussions with the National Cybersecurity Directorate and people there also led us to think of this concern, because they also do not necessarily, they're hesitating on whether to require consent within the bill in regards to the protection of privacy of employers within the cyber bill. And also the narrow and partial testing of proportionality, as is evident from our analysis of all the court decisions, without an in-depth examination of the technology itself, might lead to legitimize any means of cybersecurity, any technology, without assessing questions of from where the data is gathered, how it is assessed, and its outcomes. And our arguments is that indeed we believe that cybersecurity should be seen as a legitimate cause, but we believe that the three approaches regarding consent should be adopted also in regard to cybersecurity. The test should be based on relevant circumstances, and there is a need to detach from securitization paradigm and adopt the economic market paradigm that I discussed earlier. In these situations, we believe that more instances will require the provision of consent by employees, or we also argue that there should be non-viable situation of the infringement of the right to privacy. And I'll discuss this in a minute. So non-waivability of some issues of privacy, also in cybersecurity, and also direct consent provided by the employee before the information is gathered. We think that in most cases of cybersecurity, this should be the case. Only in extreme situations of securitization, it might be that consent will not be required. And we also argue that courts should conduct a deeper analysis of the technology and use technology experts in applying the test of proportionality. And they also differ, a point that we go into in the paper, between technologies, between types of businesses, between the information that is protected, as we elaborated in the table above. And if I go back to the Iranian hacking example that occurred this week, We believe that in both databases concerning also Atraf and also Pegasus, it's not an issue of securitization, even though there are very private, a lot of private information there. These are both not situations where no consent is needed. That the employers in both these companies should receive the consent of their employees in advance to monitor the relevant data. And I'm stressing relevant data because not all data is relevant for protection of these databases. And we don't believe that consent should be abandoned. And some of the situation, there should be also protection of privacy that is non-available, where consent will not be needed at all. We also argue in the paper that we don't believe it's enough for the courts to follow our suggestions here, not only in regard to consent and also and regarding reasonable measures that should be taken, but there are three arguments that can be made why there needs to be legislation in regards to the right to privacy of workers in cybersecurity. The first is that the basic idea of the protection of privacy, the person's control over his or her information, as well as the consent requirement, does not necessarily conform to labor law doctrines, particularly the idea of non-waivability, and the absence currently of discussion in the Privacy Act in Israel is highly problematic and should not be followed within the cybersecurity bill. Most cases, as we saw, deal with ex-post protection of privacy, and there is a need for ex-ante protection that can be achieved through strict regulation and demands within the regulation. And of course, we have the model of European data protection regime, particularly the GDPR, that emphasizes the importance of regulating the right to privacy and the need to think more carefully about the protection of privacy at work. It's also evident in the current cybersecurity bill that had decided to adopt a particular article on the privacy of employees, and hesitations about its valuability, we argue here, are not in place. We believe that there should be such a regulation. Our proposal is not to see cybersecurity as privacy as always conflicting. Of course, there are interests of employees to protect their information on databases, but that privacy in the workplace should be examined in a more complex way, recognizing that the securitization paradigm is relevant in a limited number of cases, that the scope and type of information that is needed should be carefully examined to make differentiations between circumstances, purposes, and businesses. Of course, protecting a database of a grocery store is not similar to protecting the database of a big bank in these current circumstances, and not the same measures nor the same rules of consent should apply in each one of the cases. And adopt mechanisms in organization while involving unions. I think this is one of our key findings, that when unions were involved, technology was discussed. And in all other cases, it was not. So even our analysis shows the importance of union involvement within the process. As I began my discussion, we would love to hear any thoughts that you have on our arguments here and on the analysis. We also have 2 points that we ourselves are debating, and we would love to hear your thoughts on them. Are there justification to accept a fourth, I don't know why it's written here forced, but a fourth type of consent, which is implied consent. In cybersecurity, for example, situations that do fall into extreme cases of securitization, where currently the courts say that consent is irrelevant, perhaps we can adopt a rule of implied consent instead. And also, I think it's really important to discuss what should be seen as included within the non-waivable right to privacy. We propose in the article data that is found in all personal technologies, such as private personal email accounts, WhatsApp groups where the employer is not included, private computers, personal smartphones. And also we suggest the protections of words related to potential discrimination like pregnancy, military reserve, and other, that these should not be monitored at all. Data in these devices that are privately owned and where the employer has no business interest should not be monitored. And also data which is related to potential discrimination that can affect the workers should also receive protection. So thanks a lot, and we're looking forward to the discussion.
Thank you very much, Einat and Gil. So we have a list of questions. In regard to your questions, if I may also just my 2 cents, then I will suggest in the first question that you raised to divide between industries or fields of work, with the emphasis, of course, being on the knowledge of the employee. So an employee in the high-tech industry, which realizes in full what is the significance of working with a computer at work, which is operating on a network which is managed by the employer. So that's the first point. And in relation to the second question which you raised, then it is true that personal belongings should be protected, but there can be an exception to that, which is applications which are either purchased by the working place or owned and managed by the working place. So for example, it can be a sharing information application. It can grant access to specific websites which are needed for the work, and etc. So sometimes maybe there can be some monitoring of work use of a personal instrument. So the first question we have is by Yali, and we also have 3 hands which are raised. So please, Yali.
Yeah, so thanks for a really interesting presentation and paper. I wonder whether the framing of the workplace is something unique, is really that unique in the sense that it seems to me that privacy in the digital age is shaped by power differences and problems of consent across the board. So maybe privacy before the digital age was something a bit different. I'm not sure, I didn't really think about it, but it seems to me that when you look, much of the discussion is about these huge tech companies invading our privacy without real consent, where there's huge power differences between me as a citizen, maybe I'm not that familiar with the technology, and it raises important issues of consent. So I wonder whether you apply a general framework that is relevant to privacy in digital age and just implement it in the unique circumstances of the workplace.
So I think this is a great question. Gil, do you want me to start and then you'll continue? I think this is a great question. I actually had this debate with Michael Beranak, who also argued that it might be that we should think of consent differently, generally, within the new domain of new technologies, where there are stark power differences in other instances, especially in relation of the individual with the companies themselves. And I think it might be really interesting, as happened in other circumstances within the law, where insights from labor, filtered into other areas of law. Ideas coming from labor filtered into consumer protection that recognizes power imbalances, and we know that they filtered into the way we address equality in other spheres, not only labor. So I think it's an issue worth discussing, and actually we're planning together with the Federal Cybersecurity Center a workshop exactly on this idea of consent and how we should think about consent in relationship to privacy. Generally, I think it's really important. I also think that the finding in our research that show that there are currently 3 ways to address consent, and we have the 4th way of, that we're also thinking of a possibility, is also interesting here, because consent is not something that we have one type of, right? And we can apply a different level of consent or a different form consent in various different circumstances, as the labor courts have done in regard to consent in other circumstances of privacy infringement, and as we think should be done in relation to cybersecurity. And I think that, again, this is this interesting way of thinking of consent through no need of consent, non-violability, express and direct consent beforehand, given beforehand by the employee, or a very limited level of consent. Could be interesting to look at other circumstances as well, but I am not an expert enough in these circumstances. So Gil, do you want to add something on that?
I'll just add that, like, maybe there is across the board problem, but we can first address this problem with respect to the workplace. And it doesn't mean that if there is a general problem that we don't need to address it with respect to the workplace. And second, I think it is still the relationship in the workplace is different from the relationship between a big tech company and users. It's more a direct relationship. I think the invasion of privacy has more severe consequences sometimes. So I think it's different.
Can I also add something? I might have to jump because I'm juggling with another call. But I think the main difference between an employee right to privacy and a consumer in this context is that the risk that the company faces from the employee are much higher than from consumers. After all, many, if not most, cyber attacks exploit intentional or inadvertent actions by employees. And obviously the employees having access to credentials and databases and servers of the company are those that can affect the company's cybersecurity resilience more than anybody else outside the company, except for maybe some vendors that have the same level of access. So I do think there is a distinction that is justified. What's interesting is that you focus on privacy versus cybersecurity, but I don't know why this would be any different from privacy versus any criminal offense or any other thing that could happen in the workplace, like an employee might be engaged in what we call in English embezzlement, theft, who knows, right? Sexual harassment. Why would cybersecurity, why would the balance that you need to strike between cybersecurity and the right of privacy be different from the balance you need to strike between any other criminal or inappropriate behavior of the employee and their privacy right? So that's a question I wanted to raise. And in the US, people really struggle with the employee situation. GDPR does apply to employees, but the CCPA, the California Consumer Privacy Act, exempted employees from the act mostly, other than the notice provision. Basically, the requirement to give some notice of data processing to the employees, the law exempted employees till 2021, then 2022, now it's 2023. So we'll see what happens. Similarly, the new Colorado law that is based on GDPR and CCPA fully exempts employees. And I don't remember what's in Virginia, but in the US, there is this understanding, whether justified or not, that employees cannot be subject to the same very prescriptive requirements that the privacy laws today, including in Israel, Europe, and some US states, apply, because it's just impossible to do that with all the employees. And as I said, there are different things to take into account, both in favor of the employee, like the consent issue, but also in terms of the risks facing the company from the employees. So it is definitely interesting, and we'll see what happens. Lastly, when I look a lot at companies to see how they deal with, basically to assess risks, and as you know, most companies have separate policies for employees, like bring your own device, right? So there's like if the employee decides to use their own device for the work purposes, they have to be subjected to certain requirements, including searching, etc., which the employees accept. We can talk about consent, but obviously it makes sense, right? If the employee decides to do that, then it's no longer part of their personal, kind of fully personal property. Now you can argue, is there a requirement for the employee to use their own device? Nowadays, especially with COVID, right, remote access, it becomes obviously much more complicated. I'm simplifying a bit, but wanted to thank you again, Einat and Gil, for the discussion.
Great, thanks. So much food for thought. I'll start with the last point because it's the easiest, right? What employee will say no to his employer? And that's the starting point of consent. If the employer comes and says, I want to monitor your device, we know that the power of the employee to say no is almost non-existent. And so the fact that employees accept employers' requirements in this regard, I don't think it implies on anything. And the fact that this is a practice also does not imply on anything. A new trend of bring your own devices is also problematic. And also if it's the employee's interest in some levels, it depends on what the employer provides as an alternative. So it's a huge discussion here, but I think that the fact that this is the practice does not mean anything. And the fact that employees consent does not mean anything. US law is very different from Israeli law and from European law regarding the right to privacy. And we know of these differences and discuss them elsewhere. So I won't go into that. I'm not sure that Israel should learn from the US in regard to privacy in this respect. But what I do want to address are two interesting other points that you made. The first is that the employee is more risky given evidence that we know that employees are the main actors through which attacks have been are made. So this brings us to profiling. Is the fact that the most large number of attacks was performed, according to current statistics, by employees, legitimizing profiling of this category of people and different rules that apply to them in relation of privacy? I'm not sure that is the case. And seeing them as all potential criminals is actually what we started with. That's the securitization paradigm. 99% of employees are not potential criminals. And the monitoring of their information and of their data, because of a very low percentage eventually of employees that partake in these activities, is non-justified in that respect. So they're not all criminals. They should not all be seen as potential criminals. And therefore, I think that the whole approach just reflects the criminalization paradigm, which we argue in this paper should not be applied to the context of work, where most protection of databases is done on the basis of business interests, so that the business will perform flowly and not stop its work, so that the data will be protected in a best way. But we know that some data is gathered, not necessarily even because, let's take the example of Pegasus this week. the fact that Pegasus has personal information on people is because of its advertising interests. So they gather information on family units, and the number of people, of credit card information. I personally don't think this should be allowed by law at all. And if to gather information for promotion or for advertisement, and then monitor the employees' right to infringing their privacy, I think this is totally an oxymoron. So, so I think that the view of employees as potential criminals is very problematic. I think, therefore, that the criminalization approach is also very problematic. And I do believe that we should turn to see this as the OECD recommended. And I think that its report is very persuasive in this respect as a business interest. And employers, we know, have many obligations according to the law to protect other things, not only their cyberspace. So why is cyber so different than any other employer obligations? This I cannot understand.
Thank you. We have various questions, but Elad needs to leave soon. So let's let Elad ask his question.
Wait, let me open the camera if I'm speaking. Can you hear me? Okay, great. First of all, thank you very much. It was a great presentation and a lot of things to think about, and the topic is very important. So thank you. I want to challenge a little bit your assumptions in building your this employer privacy centered model. I think in two different dimensions. One, you're saying we should not look at this kind of relationship through a prism of security, but of economic power. And I think it can easily be justified if you think about this paradigmatic case of an employee in a bank, in a software company, and his relationship with his employer. But when we use other contexts, for example, employers in critical infrastructure companies, think about employees in an election committee. When we see cyber attacks hitting this kind of businesses, this kind of facilities, the security prism, I think, might be more appropriate, or might allow us to consider the different interests and rights at stake more evenly. Do we want to lose some of the privacy protection on employees in an election committee if it gives us a lot of more protection to our election system? I don't know, perhaps, but in this case, I think that security lens would be more would be helpful, at least to make the necessary trade-offs. And add to that the fact that I think most of your framework deals with employer versus employee relationship, but I think one of the unique problems or challenges in cybersecurity is that the same data, the same email box, the same computer, we have more stakeholders that have an interest in the content and in the data of what we have. And just to think about cases that if you want to protect the privacy of the employee, you have less protection on the privacy of the customers. So what are the trade-offs then? How do you factor in our goal to protect customers' privacy versus the privacy of the employee? And another actor here is, of course, the state. In this case, the directorate. Would you allow them to see some of the data of the employee without allowing the employer to see that? Sometimes they have an interest in viewing that data because it allows them to collect intelligence or to provide a better security for the company. So all in all, I think that once we open the lens a little bit and look at all the actors involved, we may see some more factors in designing the legal regime that should be taken into account.
Thanks so much. So let me share again our PowerPoint and take you back to this slide. So first of all, we agree. We agree with what you say, Elad, in the sense that we too think that there are some situations where the securitization paradigm should play a role, right? Should be the one that is used in national security and significant social and environmental purposes, when there's strictly confidential materials, or where the damage is too high and it's really difficult to balance with other interests. So we think that in these circumstances, and I agree with you, for example, when there's a critical security establishment that needs protection, like the pool in Dimona, of course, or situations where there can be harsh environmental results from a cyber attack. We think that in these situations, the securitization paradigm is justified. But these are very limited situations, and we have to remember that, because most situations are of economic and business orientation, where the employer has obligation to protect databases, and of course it's also databases that includes those of the employees. And in those situations, again, as I said earlier to Danny, we do not believe that a different rule should apply to cybersecurity in regards to other employer obligation. There's nothing very different in the cyberspace in that regard. Now, we have to remember that employees have generally chovat ne'emanut. How do I translate that to English?
Duty of trust.
Fiduciary duty.
Fiduciary duty.
And these obligations apply to any information that they know of during the work, and of course, I think that when we require them such of fiduciary rules in very strict circumstances, we can apply stricter protection of the cybersecurity. But again, it's not applied to all employees within the workplace. It's not relevant for everyone who is within. Not all people within the workplace should be monitored the same way on the
and
same.
how do you, I'm sorry to jump in. How do you resolve conflicts between the fiduciary duty to the employee and maybe other fiduciary duty to the data of the customers? Sometimes these can come into conflict.
Right. So first of all, we know that in, why I have a background noise from something.
Sorry.
First of all, thank you. First of all, we know that in many other workplace instances, we have customers involved. We live in a service world. That means that 90%, for example, in Israel, of the work is of service economy. So if you, for example, employees have a right to strike, but their right to strike means that children, for example, if the teachers strike, will not have a right to education, right? The right to education will be infringed. That doesn't mean that you'll not give employees the right to strike.
It means
So
that we'll limit it. We make some.
I agree. Okay, I'm just taking. So this is our starting point. This is not the only instance within the market where we have interests of other people involved, especially in a service economy. So if we have the interest of other people involved in a service economy, including customers, I think it's interesting, exactly as you said, to think where the balance is. And this is why we say that we have to give much delicacy to circumstances. It depends on what's the interest of the business, what's the goal, what's the data, is it a big employer, small employer, is it, as we mentioned in the table and afterwards. And so protecting the privacy of customers is extremely important, but it's not such a securitization interest. and again, it changes because a list of customers in a grocery store is not the same as very delicate financial information And again, we're not saying that it should not be protected. We're just saying that reasonable measures should be adopted and that consent should be required in a much heavy way from the employers, exactly like we require from their fiduciary to the business. Gil, you want to add anything?
I'll add that we also saw a similarity between implementation of Isakov Inbar and the cybersecurity, or our approach regarding cybersecurity with regards to consent and camera surveillance at work. So there are places that are more public, like the entrance to a store, and there are places where there are more private places, such as workers' offices. So the consent requirement is different in different situations.
Thank you.
Thank you very much. So our next question is by Yuval. Please, Yuval.
Thank you, Gil and Einat. It's an interesting paper, and I think you raise and I think the approach you recommend is I generally agree with it, that it's you have to adopt a nuanced analysis, a context-dependent analysis, that consent is not the beginning and end. I think that's a sound approach, but I do agree also with some of the stuff Elad said. I think it's somewhat tricky to draw the analogy between the labor cases you mentioned, which are mostly about the relationship between the employee and the employer, concerning the time monitoring, the use of the emails in a case between the parties. I think the configuration in most cybersecurity cases would be different, and that would be a situation like the one we are seeing now with the Black Shadow attack, where the employer and the employee are actually on the same side of the battle line, and the question is, how can you effectively protect the company interest, but also protect, as Elad said, the clients, and in some cases it will be protecting the cyber security ecosystem more broadly. And here I think the basic assumption that the basic assumptions that we have about inequality and about concern about trust. How much do we trust the employer? They are very much diluted here, because the company also has concerns about, business secrecy, what have you. So they will also be somewhat not too keen to to open excessively their information in front of the different authorities. So I think that's a somewhat nuanced. Now, of course, you do mention that there are all sorts of cybersecurity threats. So what you refer to as the behavioral threats are probably a different category, where the analysis is probably more analogous. And if you are concerned about inside job, about an employee actually handing out the passwords or what have you, there I think the analysis works better. So this was the one, the main concern I had is how much can you learn from the labor cases, the traditional labor cases, to probably the more paradigmatic cybersecurity cases that you will encounter at the workplace. I'll just mention briefly also the issue of unions. I think it's a very interesting issue. I might have missed it, but you mentioned the involvement of unions in the labor cases, in one of the labor cases, I think Kalanswa, and you also, in both of them, and you also mentioned in the recommendations, but in between I haven't seen reference to any practice that we have concerning the involvement of unions in any cybersecurity case so far in Israel or outside Israel, and I'm wondering whether you have modalities that could be thought about or invoked in this context. Thank you.
So how much can we learn from the privacy cases that mainly discuss employer-employee conflict to the situation of cybersecurity? Let's take the Kalanswa case. I think it's a good case because it discusses hours of work of employees in a municipality that is funded by public funds. And that issue was also included in the judgment of how do we address the interest of protecting public funds on the one hand, where we want to pay workers according to the hours where they spend at work because there's a public interest here, with the right to privacy and the employment relationship. So in many of these cases, it's not only an issue of employer-employee. It has other parties involved, whether it's funding, like governmental funding, or impact of decisions regarding the issue of privacy on other parties. I think it's, again, not that different from cybersecurity and the need to protect customers. That now what we see on the recent in the recent situation where you say the interest of the employers and the employees was similar, I agree with you, because the discourse was around the hacking and the business and the data. There was no discussion on the infringement of the rights of employees. But let's say that, for example, one of the employees would have raised this point and said, you know, you used my personal data, for example, to monitor me when the hacking was, I don't know, from someone else. And as a consequence, you infringed my right to privacy and equality, then the discourse was different. So it wasn't part of this discourse because nobody raised this point whatsoever. So I'm not sure that's a good example, but I agree with you that many times there's shared interest here. That's the first point that we made in our model, that there's shared interest of employees and employers in protecting the cyberspace. And the interesting question is what happens when there is a conflict. So first, I do think that we can learn much from the privacy cases, because in many of these situations, there are third parties involved. Not involved, that are affected, third parties that are affected by the decision regarding privacy. And the second thing that I wanted to say, that we too found it very interesting that in these two cases where the courts discussed technological issues and the reasonableness of the technology were when there were unions involved. One is Kalanswa and the other is the Histadrut with the cars of של השומרים במשרד הביטחון, של משרד ראש הממשלה. That a new device was implemented within their cars, gathering their personal information. We don't have in Israel enough unions involved in cybersecurity. I think that's a shame. Last year in Europe, there was an agreement between European trade unions and European employers. They have a very, very interesting framework agreement on the digital age and the involvement of unions in the process of implementing and redesigning technologies within the workplace, including cybersecurity. And I think much can be learned from that model. Gil, you want to add anything?
I'll add that one of the main concerns that we raise is that employers will use the cybersecurity framework in order to monitor their employees in other employer-employee issues. So we show a lot of other privacy issues between employer and employee, but we think that employers will use all the securitization around cybersecurity in order to monitor their employees in other aspects.
Thank you very much. So we have 2 questions left. one from Toronto and one from Jerusalem. So let's take a tour to a colder place. Dafna, please.
Yeah, I actually I was ready at 8 a.m., but then I remember that it's only 6 hours now. Thank you, Gil and Einat. It was very interesting, and it's really such an important issue that not developed enough, I think, and so it's good to. I really like the idea of the privacy protection bubbles, because really in the digital age in general, we see how consent really loses from its impact, and of course that in the labor market it's even more important there. So I think it's a good concept. I have two questions. The first is, it kind of relates to what Elad and Yuval raised. You talk about the change of paradigm and how we need to, you talk about Nussbaum and how we need, maybe if we see it through a different lens. So instead of security paradigm, the economic paradigm, it will change the balance maybe for the right to privacy. But I wonder, we talk specifically about the cyber attack, which poses risks for a company of, I don't know, like ransom of billions of dollars, can really shut down a company or several companies, of course. I wonder if it will really have a strong impact in this specific case, to shift from a security paradigm because of the major implications that cyber attacks has, even if it's not a national security related. And lastly, I wonder if maybe more emphasis should be given to the issue of infer data and metadata, because today in the labor market, an employer, you know, once I have a phone of the company, then they can track my location, the times that I left the office, et cetera, et cetera. And part of the writing about metadata and why is, I mean, we used to think that metadata is not considered to be sensitive data, but we know today that this is not the case. Part of the reason for that is that it's not voluntary to give this information. So, I mean, maybe we need to think about how we relate to that. You mentioned maybe that specific words in the data collected should be given more emphasis, but maybe it's not just the content, but this whole information. And is it really necessary to collect this information for cyber protection? That's about it, I think.
Shall I start, Gil, or do you want to? Yeah. So I think that random is a huge problem, but I'm not sure that by monitoring more forcefully workers, this is how we'll solve the problem. And there are other efforts that are made to address issues of randoms in cybersecurity attacks. So the fact that we're all the time using the method of collecting, you know, monitoring employees' behaviors, seeing them as potential criminals, gathering more information on them instead of looking at other tools that can be used to address these very problematic, situations. I think that's the wrong direction. I think the direction should be, as the direction is now, about randoms and how to address randoms and the discussions around that. And I think they're much more fruitful than constantly monitoring employees, which I'm not very sure that this is helpful in the same way. So I think we should be very careful in assigning, all illnesses of cybersecurity to restrictions and we're offering very minimal restrictions here, not those huge restrictions, but in restraining a bit, monitoring on employees. I think that these illnesses should be dealt with other ways, and that we can absorb as a society a bit of limitation on monitoring. About the metadata, I think this is an excellent point. We haven't thought about that at all, but I think you're right. It might be that it should be more than words that receive coverage, and we should really ask the question. And that comes into, it does come into questions where we talk about proportionate measures, what data is collected and for what interest is the data collected. And once labor courts and or any other mechanism will require employers to strictly look at the process itself, what data is collected, how it's assessed. I'm sure most employers are not aware of this at all. They just, buy cybersecurity measures that are sold to them, implemented within the workplace, and are not very aware of how the technology itself works. But I think that if this will be required by the law, then these issues will be addressed, and we'll think more about the metadata issue. So thanks for raising it.
Thank you very much. So our last question will be by Gadi. Please, Gadi, who has waited very patiently.
It was an honor to listen to the previous questions. And of course, thank you for the presentation. And I have some practical insight, and I wondered what you think about it. One of the things as a computer investigator I took advantage of is the fact that most people don't even know the amount of data being saved by their own system without their knowledge. And this is especially true for cybersecurity, since the main methodology of cybersecurity is to find deviations from the norms, and these types of deviations are an indication of a cyber threat. So, but that intrinsically means that it's going to collect everything all the time about everyone. And that the basic for cybersecurity is constant logging of everything, including data, metadata, and even a behavioral analysis of information. That being said, it's an inherent contradiction, supposedly in privacy, regarding the first step of the collection of data. But that means that the main paradigm now should be not the collection, because I think it's automatically, since cybersecurity is about deviation, you have to forgo the first step of collection. But the main discussion now is in Hebrew, in privacy, it's called tzmidut hamatara, is to make sure that once the data is in, it's not used for other purposes. And this is something that already happened in my workplace, at the Competition Authority, when they entered a new system and they made the mistake of sending me the draft. And since I'm a computer investigator, I noticed, and I told them that it's come the day they entered a screening system where you can't go to certain illegal sites. But I told them that for that reason, you have to go through every site. Because how do you know that I go to illegal sites without knowing to every site that I go to? And they didn't know. They checked their own system, and it seems that they have a log of all the sites all the workers in the agency went for 3 years. Even the employer didn't know that. The IT system didn't know that. Only after asking the vendor and having a specialist open did they notice that. And then I made them promise not to use it unless they had a reason for a cybersecurity threat, and only for that purpose. So it couldn't be used for any other purpose. That being said, I think I wonder how your paradigm can work if you know that there is the inherent or the intrinsic need for copying everything. Everything will have to be copied anyway. That's the only way to protect an agency. All the incoming, outgoing traffic will have to be in some sort of way logged and copied and saved.
So thanks. We of course know this. But after consulting with a few cybersecurity experts, we understood a few things. First, this idea of bubble protection for a few words, which we know is offered in other areas of privacy protection. Also, the GDPR in some ways prohibits a collection of information that might infringe some rights. I think that this, what these experts told us, that if there's going to be protection, for example, for a few words or adjustment of words, it won't affect the ability to do behavior analysis on the basis of the data that is collected. And so if you have any other input, we would love to hear that too, of course. And also from the sources where we collect the data. And all this goes to our category of non-waivable situations of the rights. So when you're forbidden from collecting data in infringement of the right to privacy. This is the last question that we asked you. So we believe it should be from privately owned devices. And I think that the comment made by, I don't remember who said it first, but anyway, the comment that we have to look also on algorithms that that are of the employer, but are within the personal device of the employee. They might be monitored. Then I think that's an issue that we should consider. I think that was a very good point. But generally, we think that the private devices should not be monitored. So by defining, and I think that's a really huge task, by defining when we see the right to privacy as non-waivable at all, and which sources we do not access, which words we do not access, that can still enable behavior analysis in order to address, in order to secure the cyberspace. I think that's the main challenge now. And that is why we also ask for your input on this, and we would love to get any input on this even after.
So I would just say from a practical experience, what your cybersecurity experts told you is half correct, in the sense that in order to create the achagot, certain words that won't go into, you have to first you have to create the database and then take it out. And this process automatically assumes that at one point or another, everything was there. Whether we took something out after it was there is a second question. But in order to protect, we first had to create this sort of bucket with all the information inside. As far as I know from a practical experience, I use this to copy data, and everything is safe. It's the only way. There is no other practical way to do this.
But okay, so let's talk about it afterwards, because I want to learn more from your practical experience. We understood otherwise that there are things that you can define within the algorithm that are not collected. And of course, you can define devices that are not monitored at all, even if you collect data. So, but we would love to get more input on this, of course, from a practical perspective. That would be very, very helpful. And I totally agree with you that the rule of Smidut Matara, or how would we say it in English, is extremely important. But we also know, as Gil mentioned earlier, that employers do not abide to it. And as Steve Adler said in a discussion that we had about this project a year and a half ago, he said, okay, let's assume that now I know one of my employees is a pedophile because I gathered data for cybersecurity. What am I going to do with that? So it raises a lot of other dilemmas in the labor context, this rule. And therefore, I think we need to address or limit, use the other rules of the consent, legitimate purpose, proportionality in a much stricter way than is done today to protect the rights of the employees.
I'll just add that your comment actually supports our argument that courts should examine more the technology, the design of the technology, and including the tzmidut hamatara, finality principle. So today, this is not examined at all by the courts. So.
It's just a general. I think I'm getting as time goes by, I'm understanding that everybody saves everything, and trying to prevent somebody from saving, it seems like a futile task, and maybe we should go with something that actually has a viability.
Thank you very much, Einat and Gil, for the presentation. And I think we got an idea for the second semester to have a workshop of how to defend ourselves from sophisticated investigators like God in the future. Thank you very much.
I think the word is devious.
Thank you very much. And we will meet.
תודה רבה.
תודה. We will meet again next time on November 24th to discuss Ayelet Gordon Tapiro and Katrina's paper. Have a great evening.
Bye, Toda.
Bye-bye. Or day.